Welcome this morning to presentations from both James Hooper and myself. My name is Tim Donaghey, and I'll be speaking about general protections with James Hooper this morning. May as well sit down, I'm going to stay for 5 minutes. Just a few words to begin with. For those of you who practice in this area, you may know me. I've been practicing in workplace law for some time. Just a few words about general protections. The nature of this jurisdiction, the nature of the conflict in this jurisdiction under the Fair Work Act means that this cause of action is much more likely than most to get you and your clients into court. Bargaining and industrial action have appeared to recede over recent years in terms of the level of conflict and frequency of that conflict. General protections, both in its intra-employment emanation and for dismissal or ending of contractual relationships in the case of independent contractors, have increased exponentially. So that's the reason that James and I have focused on this today. James, I think, will be speaking about Section 341(1)(c), complaints and inquiries, and I'll be speaking about the remedies aspect, the wash-up, if you like, at the end of the day. So with no further ado, I'll hand over to James. Thanks very much.
Okay, good morning, and thank you, Tim. Before I begin, I'll just give Tim may be too modest, I'm not sure. I might be preempting him, but give his, he's just finished editing the second edition of his textbook, which is called General Protections under the Fair Work Act. So you can tell that he knows a lot about the general protections provisions. He's just finished that with his co-author, Emma Goodwin. So it's not out yet, but when it comes out, buy a copy. You owe me a free copy, Tim. Thank you. I'm James Hooper. I'm a barrister. I've been at the bar for approaching 7 years now, and before that I was a solicitor for about 12. It's all been in the area of employment and working both sides of the street, if you like, employers and employees. Now, I'm speaking about the very common general protections claim, or common in my experience anyway, which is to the effect that a person, usually an employee, make some sort of complaint or inquiry in relation to work, or so they allege, it's in relation to work, and they further allege that they suffer an adverse outcome or action because of it. And because of the nebulous nature, if you like, of workplace rights, and especially those in relation to employment, it's very general. So most often, if you think laterally enough, you can come up with some sort of complaint or inquiry that might have been made that could perhaps found an action. Sometimes they're very solid. Sometimes they're somewhat spurious, but with some creativity, I think it's just about always possible to generate some sort of action. Okay, and look, as I've said, the claims are common. I just think, you know, given human nature, the amount of workplace conflict that is out there, you know, God bless it for all of us in this room. We've all seen general protections matters involving, you know, allegations that a workplace complaint was made and adverse action taken as a consequence, and they'll just keep on coming. And there seem to be fertile disputes over the length and breadth of that particular workplace right in relation to making complaints. So let's just hope there are lots of disputes in the courts for the foreseeable future. The relevant protection is founded in Section 340. Basically, that says thou shalt not take, doesn't actually say thou shalt, but paraphrasing, thou shalt not take adverse action against someone because they have or they've exercised a workplace right. And you then have, I think of it as acronym BRA, B-R-A, you have your because in 340. You have your right in 341, and you have your action in 342. And mentioning the obvious, look, 340 claims are subject to a couple of things helpful to employees. It's a reverse onus of proof in section 361. So if the employee can get over the very low hurdle of showing that there was some sort of adverse action and they had some sort of workplace right, then effectively they usually get to bring their action. And from that position, the employer has to establish there was some sort of innocent reason that excluded whatever the employee is saying is the reason for the adverse action being taken to be successful in its defence. And there's section 360 as well, which is basically to the effect that if there were a range of reasons, all of them lawful except perhaps one which was taken because someone had a workplace right, that a reason in relation to the workplace right only has to be operative, feature a bit, and the employee's claim will succeed. Now, so I'm in section, you get section 340, 341 and 342, operating to make a successful breach of general protections claim. I'm drilling down into 341 subsection 1 C. Now there's a range of workplace rights, A, B, C. I'm in C, which is the right to make complaints and inquiries. There's effectively two sorts of complaints or inquiries that can be made under that particular subsection. And I just thought, my reflection while I was sitting at my desk in relation to the two most common claims, called garden variety claims. They come across my desk. I think they stem out of the dodgy employer claim, where there's some employer who's been not affording an employee their entitlements. The employee brings that to the employer's attention, and shortly thereafter they're sacked or demoted or their hours are cut back or whatever. They're the ones where you want to be on the employee's side. And then another sort of common variety, and this is what I call the employee-generated claim, which seems pretty common. You've got bad relationships at work between employer and employee. Employees, adverse action is taken against them. Usually they're dismissed, and they can't bring an unfair dismissal for some reason. They're looking for an action, so they cast about for some sort of, and if there's been controversy going on at work, allegations, complaints, inquiries, etc. have been thrown around, and they'll grab onto that and say that was the reason for the adverse action. And sometimes those employee arguments can be pretty spurious. But I see that those two sorts of claims commonly come across my desk. So the inherent limits to section 341C are the language of the provision itself. So 341(1)C is split into two parts, if you like. The first is that a complaint or inquiry, or the sort of complaint or inquiry that's made to a person or body having the capacity under a workplace law or instrument basically to seek compliance with that law or instrument. And note that protection, as opposed to the next one, this particular protection extends to the full range of people mentioned in section 342, so employees, prospective employees, contractors, etc. The other sort of claim under section 341(1)C is that a complaint was made, and this is the most controversial one, in relation to employment, which is a lovely nebulous term, which is the source of much legal debate and cause of much legal action. And obviously that particular one only extends to employees, because the complaint has to be in relation to employment. Now, in relation to 341(1)C, Roman numeral 1. In a nutshell, for I characterise these. Look, these complaints are usually, obviously, the two sorts of complaints under section 341(1)C can be divided pretty simply. The first one is usually to a regulator, to the ATO or the FWO or the FWC, or an application to a court, something like that. So they're the body who are there to enforce compliance with a particular piece of legislation. And the second one more generally pertains, or generally in the actions that are brought, are more important where in those circumstances where an employee has brought a claim against their employer. So in relation to those complaints to regulators, my take on it for the complaint to be in relation to employment, and for the no, sorry, I'm talking about this is the complaint to the regulator. The body complained to, so whether it's the ATO or the FWO or maybe the Equal Opportunity Commission, under the particular pieces of legislation they govern, the body that the complaint has been made to, and the statute that the body regulates and enforces, need to have a focus or be in the business of regulating the relationships between employers and employees. It's not sufficient that merely a body exists and a statute exists. That main function is something else other than the regulation of relationships between employers and employees. A complaint to that sort of body, perhaps a civil aviation authority, there's been a complaint under legislation that body governs. And then there was a complaint to very recently in relation to a decision that came down last Friday to ASIC under whistleblower protection provisions in the Corporations Act, where the central focus of those bodies and the legislation is not regulating relationships between employers and employees, it's regulating civil aviation, or it's regulating corporations. And just because employees might have obligations of or an ability to report something in relation to corporate regulation or civil aviation regulation doesn't mean that that particular body or the statute has a sufficient focus on managing employment relations for it to be a valid complaint to be able to make to found a workplace right. So, just quickly going through some examples, a little bit of a grab bag if you like. Examples of complaints to regulators where the complaint has been protected as being a complaint to a body enforcing a piece of legislation that sufficiently pertains to employment relations. Back in 2008, and just thinking of obvious examples from the obvious areas, there was Dowling versus Fairfax Media Publications in the federal court. That was I think everyone's going to intuitively feel a complaint under work cover legislation to a work cover body is a complaint that be brought, and that complaint was protected. Then there was Tatsbet and Morrow, a decision of Jessup that was perhaps slightly more peripheral, a complaint to the ATO, which you wouldn't think is centrally in the business of governing employment relations, but it was in relation to super guarantee, and that's something you get for working. So that was found to be sufficiently that was found to be sufficient to be a complaint that was protected. A little side point that was interesting came out of that was Ms Morrow, who made the complaint about to the ATO, I haven't got my super guarantee monies. Ultimately, it turned out that she wasn't an employee; she was a contractor, and she wasn't entitled to the super. So it was a mistaken complaint that she'd made, or she'd made a mistake in fact. But still, and she made the complaint in good faith, one must assume. The fact that she made the complaint to that body in relation to super guarantee payments and employment entitlement was sufficient to get her the protection, even though she didn't have the right to the entitlement. Again, looking at, and then you've got Bayford and Maxia. There's a decision which intuitively I think we'll all feel about discrimination related to the workplace, to work, to the Equal Opportunity Commission under the Victorian Equal Opportunity Act. That complaint was protected in that matter. Similarly, we have occupational health and safety complaints in Ermel versus Dulux Group, a Bromberg Federal Court decision. And then interestingly, look, just last Friday we had this decision handed down in the Environmental Group versus Bowd by Justice Stewart in the Federal Court. And that was the matter I was referring to, where CEO blew the whistle on the Environmental Group, Mr Bowd, on the Environmental Group, and he made complaints to ASIC, the Federal Police and the Victorian Police. So he made, and to the board of the organisation, he made complaints everywhere. However, Justice Stewart found that that claim under the that whistleblowing, if you like, under the Corporations Act wasn't protected, and we'll have a bit more of a look at Bowd in a minute. Okay, so now looking at that second branch, complaints made. So that deals with the bodies of the complaints that people make to the regulatory bodies. Now looking at that other branch where complaints are made to employers in relation to employment, there are two particularly contentious areas there in relation to what in relation to employment means. The first is, does the complaint have to arise from a statute? Or a regulation, some sort of formal regulation, or a contractual right to be in relation to employment? That's a vexed question. And secondly, does the complaint have to be in good faith? And I think that's the good faith question is interesting, because sometimes it seems that general protections claims are used as a bit of a sword to fight off, if you like, disciplinary outcomes or fair enough criticism, rather than as a shield from illegitimate adverse action. As I said, look, I'm both sides of the fence, so that's just an objective observation. Often the claims are very good. You just see the odd one where you think, maybe they're using that to sort of push back at the employer in circumstances where perhaps there's not very good grounds for it. So in relation to, okay, and I'll keep this very simple as time is short. In relation to the question of whether inquiry has to have a complaint or inquiry has to have a basis in statute, regulation or contract, keeping it simple, I've said, well, there's a no camp. There are a number of decisions over the years, and there's just a selection of them and, on that overhead. What I call the no camp, the decisions where they said, no, there doesn't have to be such a link. It's a wider concept than that, complaint in relation to employment. We don't want to fetter it or narrow it by tying it to the, a statute, ability to complain about something in a statute or a regulation or a contract. So you've got, back in 2013, Jessup in Murray and Bedeasy. The following year, you've got Bromberg in Walsh and Greater Metropolitan Cemeteries, and you can. And you can see there the 4 dot points under the Walsh case, just how sort of nebulous the concept is. Well, nebulous in my view, in relation to is to be interpreted widely. All that's required is a relationship between the subject matter of the complaint and the employment. If the subject matter of the complaint raises implications for employment, then there's likely a sufficient nexus between the complaint and the employment for the complaint to be protected. And then, again, Tracy in 2016 in Trevena versus Thies. So that's the no camp. No, No, there doesn't have to be a link to the statute or contract. There's a yes camp, which I think was, in my view, was a less influential view, and the decisions were following the no camp. No, there doesn't have to be a link, but look, probably the most important, or the one that everyone thinks of in relation to the yes camp was Justice Dodd-Streeton in Shea and True Energy. She said clearly, yes, there did have to be some sort of entitlement in a statute or contract or regulation to complain about for the complaint to be protected. Now, a bit of a spanner was thrown in the works, in my view, last Friday. Until last Friday, I think we were going down the no, there doesn't have to be a link to a statute or contract view, as following the line of reasoning from Justice Jessup in Murray, and so thereby leaving the scope of complaints wide, and that perhaps creating some uncertainty and a need in a lot of cases on a fact-by-fact basis for a party, especially the employer, to distinguish their particular factual scenario from the cases that followed or that had preceded it, in an effort to say, well, no, this complaint wasn't in relation to employment on the facts. So last Friday, Justice Stewart in Environmental Group and Bowed, well, he swung back to the yes camp. He said, yes, there does have to be a link, and he resuscitated the reasoning of Justice Dodd-Streeton in Shea and True Energy, and said, effectively, the complaint must be underpinned by an entitlement, a right, and said, for example, or statute or regulation, and extended it to acknowledge that it would extend to a contract. Now, but to me, there's some room to argue in relation to that decision. Justice Stewart referred to a decision earlier this year of the full federal court in the I call it the cigarette case, Cigarette and Gift Warehouse versus Whelan, where Greenwood Logan and Justices Greenwood Logan and Derrington said that a complaint that an employee is able to make, confusingly they approve both the, if you like, the Jessup wider view of what sort of complaint is protected in Murray, and they also referred approvingly to Dodd-Streeton in the Shea decision, and they left some ambiguity in there, though. In my view, look, I've put in bold there, the entitlement must be, a claim must be founded on a source of entitlement, whether it's an instrument, so, your statute or your contract, or your statute or your regulation or your contract, or otherwise. Now, otherwise just sort of leaves the door wide open, but then Justice Stewart later was referring to that decision and basically saying, well, the full federal court had closed the door to the extent on the width of complaint, but it seems to me that it's possible that I'm not sure whether the Stewart decision will be appealed, but the door, although it's swung shut, it hasn't swung shut very firmly, and it might swing back to the sort of Murray-Jessup line of reasoning. Okay, and now I'll just jump forward a little bit. So, look, that's where we're at with complaining to regulatory bodies. Door seemed to swing shut on the sort of complaint that can be made last Friday, but I think it may swing open again. Second contentious issue has been, do complaints have to be made in good faith? Now, again, Justice Dodd-Streeton in Shea said, well, yes, they do. In that, she found that there were allegations of sexual harassment that were made that weren't made in good faith, and if you like, were used as a shield, a sword rather than a shield, in relation to problems that Miss Shea and her personal assistant, they were both made redundant, only persons in the organisation to be made redundant, so they felt they were singled out and treated adversely. She found those complaints were baseless, not made for a proper purpose in good faith, and so those complaints didn't get the protection of general protections. whereas Justice Stewart said the complaints made by a CEO to a board, to ASIC, to the police, to federal police, there were complaints everywhere. I took from the decision that the judge thought that was a bit of a cynical play to get protection. The CEO was acting, hadn't been there for long, the organisation wasn't travelling well, morale was low, people were leaving, is what I gather. And the board had raised performance issues. There was good evidence in terms of emails going backwards and forwards that the performance issues were there before any complaints were made by the CEO, and Justice Stewart wasn't convinced that those complaints were made in good faith. Look, the situation's currently uncertain in relation to the impact of good faith and the need for a complaint to be linked to, the statute, a regulation, a contract. My view, look, everything seemed to be travelling along the Murray path, and that was prevailing over, if you like, the narrower Shea path. And I note that the appeal judges in Shea didn't disturb what Streeton had said in her decision, the actual appeal of Shea itself, but they did sound notes of caution and said, effectively, before you swing the door shut, you've got to consider the purpose of the legislation, etc. What is the purpose of the general protections? Well, the title gives it away. It's protections of workers. So there's a tension going on, if you like, between the law seeking some sort of certainty and narrower ambit, rather than leaving this just in relation to employment, rather nebulous concept where you can argue anything's in relation to employment, leads to too much litigation and confusion, perhaps. Again, and the tension is with, if you like, the purpose of those general protections provisions, which is to protect employees. So let's just all hope, we'll keep litigating and keep briefing us at the bar, and we'll try and sort that question out. But until we get perhaps some sort of High Court decision in relation to all this at some stage, the confusion will remain in relation to what's a workplace complaint. That attracts the protection of the general protection provisions, and let's all litigate it to the hilt. That's what I say. So thank you.
James very generously gave a bit of a plug to my book, not only my book, also Emma Goodwin's book, as you can see from the first slide. I have just finished editing the manuscript on this book, which I think is the first commentary on general protections as a whole. I'd love to lie to you and tell you it was a labour of love. It wasn't. Writing a book is always hard, and general protections, through most of the loose definitions and what can only be described as deliberate obscurantism by Parliament in some of the definitions, some of which Jimmy has touched upon, really makes the process of commenting on the legislation absolutely at some of its most tricky. But the process is over, so I'm here to tell you that in several weeks LexisNexis will be publishing this book, and I'll be able to say with some authority that I've read all the cases on general protections, and quite a lot of them I just don't rate at all. The point of my discussion today is to look both at the very beginning of the process and the end. The very beginning, of course, is when a client comes to you and says, well, what am I up for? What's my position in relation to this GP claim that I've received? And the very end is that unfortunate fact where you face, well, maybe you've lost on a couple of points, maybe you've lost on more than a couple. What is the client's exposure in terms of the potential orders and relief? And some of it is intuitive, some of it you'll come along with me on this journey, some of it is perhaps less intuitive and probably deserves a bit closer examination, in particular of the statutes. So this presentation explores factors contributing to orders for reinstatement, and I've broken it up into these three: injunctive relief, compensation, and the other stuff. Now, I do talk about reinstatement, but for simple time considerations, I talk about reinstatement less than other types of relief. And that's very simple. Very few reinstatement orders are made under general protections. There's been one recently in Cummins and Keenan, which is going to be subject to appeal. But the fact is that that particular case is going to be subject to a fairly robust appeal, in my opinion, because there are very many discretionary factors which go against reinstatement. But this is for the moment the outline, and you can see there basically what I'm intending to say. So factors first. Let's talk about reinstatement quite briefly. Reinstatement is what it sounds like. It's either remaking or mending what was the pre-dismissal contract of employment. Now, back in the early 90s, it was a period in which the IR court was the most active. There was a sizable debate about whether reinstatement was instatement, that is, creating a new employment arrangement, or reinstatement, fixing the one that was broken. Largely, the statute, the way it is now, ignores that question entirely. So reading the old cases is of relatively little benefit. But the important point here is the subsection on 3. The power that the courts are given is given in a particular way, and it's reminiscent of discrimination statutes. 545 sub 1 provides globally that the Federal Court and the Federal Circuit Court may make any order that they consider appropriate following on from a contravention. Enormously broad power, not without precedent. Similar exists in the Disability Discrimination Act as well as in other discrimination jurisdictions. That's a big hint, folks. General Protections is a quasi-discrimination jurisdiction, kind of with freedom of association on one side and perhaps a little bit of termination of employment on the other, all smushed together under the one roof and with the same remedy regime, the same powers that apply to all. So what I'm about to say also applies to other breaches under the Fair Work Act, but I'm doing it kind of from the general protections perspective because A, that's what my practice is, and B, that's what I spent the time writing the book about, so why wouldn't I? 542, on the other hand, is a non-exclusive list of the types of orders that the Federal Court and the Federal Circuit Court can make. So it includes reinstatement, injunctions and compensation, and I kind of step over reinstatement to get to the other two because they're the biggies. So as I say, a few reinstatement orders are made. Making a new one doesn't really matter. I've had several cases in which reinstatement orders were made at first instance and then unmade on appeal. Now that gets tricky, but that's not what I'm focusing on today. Okay, so judicial considerations. Because of the very wide discretion available to the Federal Court and the Federal Circuit Court, none of the cases with a specific test for reinstatement, Perkins and Grace, some of the older ones, strictly apply. But they all consider discretionary questions, so they all have some impact, but must be read in the light of the current section 545. So questions about what is the reinstatement proposed? Does it include an obligation to work? Then you turn to Ramsey and Blackadder, which is the High Court case where the fellow was put back on the books at the abattoir, but not actually given any work to do. And the High Court said, no, you can't do that. Reinstatement means the right to work. Perkins and Grace is the IR Court, kind of the foundational case for reinstatement, but that considers the question of whether the reinstatement's impracticable. So that ultimate question to one side, the other discretionary questions still have an impact upon reinstatement today. Other lesser issues, and I mean lesser because they very seldom arise on the facts, and if they do, they're not of overwhelming weight, include the other bullet points. Was there animosity? Would reinstatement lead to embarrassment or some difficulty in the workplace? These are all minor considerations. Formerly, there used to be an examination of trust and confidence. Now, that still exists under various guises, under the question of whether parties can work with each other, but Barker versus Commonwealth Bank has largely put the question of trust and confidence out of the contractual nexus, and one gets the impression from the judges in the Federal and the Federal Circuit Court that they don't much like the question either. The High Court's spoken and everyone's moved on. Capacity and conduct. It's not appropriate to reinstate someone where where there's a performance issue that indicates they couldn't do the job, or to go for a case called ALEA versus IAS, which is a Barker J case from about 2012. The poor fellow who had been dismissed for his employment had lost his right to work. what today is Border Force and Migration had taken away his visa, so reinstating him would have been essentially useless, and he was given a sizable amount of compensation as a result. Further considerations, what's no longer taken into account, you can see there on screen, there's a few questions that don't really matter, and I refer to Quinn versus Overland, a Justice Bromberg decision. And the last on the slide is the case I referred to a moment ago, Keenan versus Cummins. Now, what's striking about that decision is that few principles are advanced. It was Judge Wilson before His Honour was elevated to the family court. It's currently on appeal and proposed to be heard in the August sittings in the full federal court. My view is that it's likely to be set aside on the question of reinstatement. There are many factors in this case, many discretionary factors which point away from reinstatement, not the least of which is the fact that Mr. Keenan was out of the business for 3 years, so he's essentially got 3 years' pay in between the commencement of the effect of the dismissal and the reinstatement order made by His Honour. But you just never know. These discretionary questions are certainly not laid down, certainly not certain in that way. Okay, so on to other forms of relief. In a way, injunctive relief has taken the place of reinstatement orders, and that's why I put some emphasis on it. Injunctions, intuitively, are really ill-suited to employment scenarios, and yet they continue to be made. Also, not a huge number of them, and they can be divided up into two categories, of course, the interim and the interlocutory on the one hand, and the final injunctive relief on the other. And I have to say, final injunctive relief, the cases on that are very few, but the scope of the power to order, particularly in relation to regulators, so the ABCC, and the FWO, the Fair Work Ombudsman, they tend to form more of a part of those kind of general protections cases rather than the inter partes employee versus employer litigation that is far more common in this space. But injunctive relief, so because general protections works intra-employment, as well as a general protections court application which relies on dismissal, one must consider injunctive relief for internal management questions. You changed my roster, you gave me a warning, and that sort of thing. And I get on the next slide, I get to the question of serious issue and the other injunctive questions. But in a general protections context, the serious issue is always going to be the strength of the allegation, the relative strength of the question. Did the dismissal or did the internal management issue arise from a prohibited ground? If it's absolutely not possible, then of course the question really falls away. Without a serious issue to be tried, no injunctive relief should go. But you can see from one of the cases on screen, Zhang versus University of Canberra, that was a disciplinary procedure challenge and one that was challenged reasonably successfully. Rescinding the decision to terminate, that's, as you can see, MUA versus Sydney International Container. That was an interlocutory injunction, so it was inter partes, both parties in court, rather than just brought by one party. And it was also challenging the decision to terminate at Sydney terminals, and successfully. And restraining an employer from giving effect to its decision to terminate. So you can immediately see there are mandatory injunction considerations and prohibitive injunction considerations at play. And that's the reason for this slide, because the standard questions to other injunctions apply to injunctions under this area of the law. So merely the fact that 545 gives a wide discretion, it doesn't actually tell the court how to do its job, and successive judges have gone back to these principles established over many years of interlocutory and injunctive relief. If you're as old as I am, you can remember Patrick Stevedores and the interlocutory injunction that went in that case in April 1998. The High Court considered it. It now stands for that proposition at 195 CLR 1. So first question, serious issue to be tried. Is it arguable that the contravention of, to pick up Jimmy's point, section 340, complaint and inquiry, or to pick up the Barclay case, 346, membership or officership of a union, is it seriously arguable? What do the emails say? What do the parties say viva voce? Now that's likely to be disputed because interim and interlocutory injunctions are by their nature preliminary. Second question, balance of convenience. What is the effect? What will this employee miss out on if the injunction does not go? What inconvenience will the employer suffer if the injunction does go? And of course the question, and you can see it underlined there in the second bullet point, is damages an adequate remedy? Quite often it will be. In what circumstances are interim injunctions often sought? Well, interim injunction is simply a word for an ex parte or very preliminary. You know, with a ship leaving port or a property being destroyed or lost, that seldom applies to general protections. Most of the injunction cases in this area are inter partes, with both parties in court having ready to slug it out, usually with a usually on the basis of evidence ready to be tendered. Now, I'm on to point 3. And point 3 is the quantum of compensation, which has several aspects. But I'm going to deal with the main one. You'll be able to see from the slides what I think of some of the other ones. But the main one, of course, in involving employment is what would have happened to this particular employee in the circumstances of the case. So it's the principal remedy sought under Part 3.1. It appears in every single case. The question, rather, is on what basis does it appear? 3 important considerations. You can see what those important considerations are. I won't rehearse them. Basically, they are repaid by a reading of 545 sub 1 and 545 sub 2. The second point, the second point there, which losses are caused by the contravention, and I've cited Wardley. The other case on that point is actually in the bullet point above, ABCC versus CFMEU, which is a 2018 High Court case considering the impact of 545 and a single judge decision from 2011, Flick J, called No Fuss Garbage. That is a detailed examination, and the only High Court detailed examination of 545 that we have today. Okay, some principles for economic loss. And I'm going to step away from the slide for a moment. The principles of economic loss for most general protections claims are very similar to the principles for compensation in lieu of reinstatement in unfair dismissal. How long would this particular employee or contractor have worked but for the contravention? You know, and that really is the source of the discretion. In the case of Mr. Keenan, obviously, with the reinstatement order that I referred to, the judge implicitly found that that worker would have worked for the 3 years following dismissal. In other cases, Stevens versus Australia Post was a fixed term contract and the fellow basically finished working. Now that fellow was reinstated for another period, but that seems to be a challenging case, shall we say it, on 545. And some of my own cases reported, Stanton Long versus Federation Training, Walsh versus Greater Melbourne Cemetery Trust, the considerations of compensation were all linked to whether this employee was performing, whether the employee would have continued performing, or whether there's an indication that maybe that part of the business was going to shut down and this employee could have been made redundant, or other general business considerations. That's our task, ladies and gentlemen. Our task is to identify what the longevity is or might be, no matter whether you're acting for the applicant or the respondent, and then bringing that out in the terms of the discretion exercise in section 545. So causation is literally the issue, and unfortunately it requires us to hypothecate, and sometimes that's difficult, but most often you get a feel for reading, when you read the cases, that all of the indicators are there. Maybe this employee wouldn't have continued serving. Maybe their performance or capacity issues would have limited them. There are certain themes, as I say, at that bullet point, loss of wages and entitlements, out-of-pocket expenses. Superannuation is an issue that is added to. So in other words, even though the employee or contractor would not have been entitled to receive the super in their pocket, not beneficially at any rate, that's the superannuation and the level of it is often taken into account in striking an amount of compensation under section 545. And you can see the underlying point there, what would have been likely to occur. I've given us a little bit of a shopping list here of cases on them, and I'm not proposing to refer to them. They are all examples that reinforce the basic propositions that I'm talking about, namely that one looks at the period of service, Obviously, for a longer employee with very few black marks against their name, it's very likely that that person will continue. For a contractor working on a building site, what relationship does that contractor have to the builder? Have they done many jobs for that builder in the past? Will they continue in the future? And so on. Those are considerations. For Touros is one of my cases, run with a solicitor who's probably here today. That fellow got 10 months. So he got 10 months because Judge McNabb said that there was a period of time where he would have worked, but for the dismissal, certainly the relationship with the employer had broken down, but he had reason based on the affidavit evidence to make that conclusion. Whereas Kai versus T. Loy & Co., almost the opposite position. No, that employee would not have worked long into the future, and accordingly snipped accordingly at the level of compensation ordered. This is the part of the speech where I engage in a bit of navel-gazing, areas of current and future development, and this is me just having a look at the briefs in my room and saying, what are the trends and what's likely to happen in the future? At the end of this, I'm going to ask for questions. I usually don't get questions on this sort of stuff, but this is the part which I think indicates what's likely to come through your door at some point. It's certainly telling you what's coming through mine. The nature of economic loss is changing because litigation is expensive and there's a real pressure from the applicant side to try and get those numbers up. Try and complain and say, this compensation for a period is not enough. I see very ambitious, I suppose is the polite way to put it, claims for compensation. I would have worked for the rest of my life. I would have worked there till I die. That sort of claim. Not all of them terribly realistic, but it has an air of unreality about it. But at the same time, with great earnest, I've seen some very large compensation claims in general protections. Non-economic loss is a bit of a furphy. It is whatever the particular judge says it is. So I've seen non-economic loss orders as low as $3,000. I've seen them as high as $25,000. They are just designed to compensate for the hurt, humiliation and distress occasioned by the dismissal or, by the other contravention. So the variety is enormous. Quite often they refer back to one paragraph in an affidavit. It made me sad, or I felt bad at the dismissal. Very seldom is there anything like a psychological basis or expert evidence to back that up. And on that note, looking at the third point, psychological and psychiatric injury material has become an increasing feature in general protections dismissal claims. But the limitations arising from 545 mean that very few of those cases succeed. Only one that occurs to me, called Cassis versus Republic of Lebanon, has ever succeeded. Now, that case needs to be treated with some caution because it was essentially run ex parte. Republic of Lebanon, for all its goodwill, did not send solicitors and counsel to court, and it was essentially an uncontested case. But to be honest, psychological and psychiatric injury cases are not only possible, they are, in my experience, increasing in frequency, and I have several at the moment where I have detailed expert evidence about the psychological condition which was either caused by or exacerbated by the fact of the dismissal. I think that's a watch this space. I don't know about you, but I'm not a personal injuries lawyer, and yet I'm likely to be engaged in that sort of contemplation and that examination of evidence both now and in the future. That's what I have to say for the moment, folks. Before I throw the floor open to questions, I just want to sit down a couple of guidelines. Please, when you state your question, direct it to either one of us or both of us, I don't mind which, and if, because I'm deaf as a post, if I ask you to repeat part of it, please don't take offence. It's about me, it's not about you. I'll answer as succinctly as I can. If you delve into too many facts, I'll cut you off. Put simply, I can't give advice from the pulpit. Thanks very much.
Hi, yes, just two quick questions for James. With respect to Section 340, complaint and inquiry, is there any authority where the employee makes that complaint or inquiry on behalf of other employees? And with respect to, what was the other one? just flew out of my head.
Will I answer that one first, and you can give out the second one? Yes, the answer is that complaints can be commonly described as indirect. There was a particular case where a brother made a complaint in relation to his brother, so it was not the brother complaining, but the brother who had the issue. He was protected. So the complaint was made by somebody else, and he was protected. There's been a similar decision to the effect of, if there's a group of people in a workplace that working in a mine, and one worker goes and makes a complaint on behalf of the others, so indirectly on behalf of the others again, then yes, there's protection.
Yeah, I remember the other one is about bringing a claim to, or making a complaint to a regulator. Is there any authority where an employee was terminated for fear of bringing a complaint to one of those, to a regulator?
Terminated for... okay, so they had the right to do it. They hadn't done it, and the employer got in first. So I'm not aware of a case off the top of my head, but I'm sitting next to someone who wrote a textbook in the area. Tim?
That sounds like a throw to me. There's no thank you. There's no authority particularly there, but it is 340. The way 340 is drafted because someone has the workplace right, because they've exercised it, or to prevent them from exercising it, it's clear that if that factually could be established, then that would definitely be protected. The real question, 340 sub 1 sub A has these three alternatives in them, having the workplace right, exercising, and so on. Not many of the cases make very much of that, the difference between those three, and usually they're lumped together in a sense that would be impermissible in a pleading, but of course if you're a judge you can get away with whatever you like. Very seldom do I find the difference between those options explored, just as very seldom does the prospective employee come up in terms of the person identified under 342. But I think the best I can say is no specific case yet. I mean, we're only 10 years into this legislation, so 10 years is barely a blip in terms of the amount of litigation that there is. But the second point is, I think yes, it would be protected. It would be able to be brought by that applicant.
Yeah, I guess they'd have a lot of other ways into the employer through causes of action under the Fair Work Act. Most likely if their employer had treated them in circumstances where they did have a valid complaint they could make, so they'd go more directly rather than sort of, try and establish what the employer's motive was before the complaint was actually made. I think that would just be inherently difficult and their easier way home. So probably why, 10 years on we haven't had one.
A question for Tim. What's your experience in relation to Form FHC applications and compensation where there hasn't been a dismissal? General protections claim, but no dismissal has been made.
That's a good question, and one that occupied a solicitor and myself in this room for, I think, 3 years, David. The real question about intra-employment is you don't end up with very large amounts of compensation. There are some cases that deal with 3,000s and 5,000s, very small amounts, because these are notional amounts of compensation, not actual cause and effect amounts such as they are in dismissal. And so if this is the Jennings versus Salvation Army example, a case which was brought under the predecessor to the general protections but gets trotted out in relation to general protections very often. An intra-employment example of freedom of association where the complained activity was simply disciplinary action or a warning or a roster shift or several of the examples I gave. So the short answer to that is not very much, and certainly not probably worth issuing an application on, though I've been involved in several that were uneconomic and yet seemed to have legs and run.
What's the most authoritative case regarding the workplace right around union activity?
Barclay. Barclay is 3 cases. The High Court one got a lot of attention, but it's an interlocutory injunction at first instance by His Honour, former Judge Richard Tracy, then an intermediate appeal with 3 judges, Lander writing a separate judgment and Gray and Bromberg writing a joint judgment, and then 3 separate judgments in the High Court, Crennan and the Chief Alsop, Gummo and Hayne, and then Hayden sitting out on his own. So basically 346 is a protection against union activity or industrial activity, and basically all roads lead back to that decision. Perhaps wait on it so I can hear you. Perhaps wait on a mic.
Tim, I've got a question for you, and the question is in relation to psychiatric injury.
Yes.
So you said that because of the broad discretion in Section 345, the Federal Court has got quite a wide discretion to make any order that they want to.
Yes.
In the cases where you've seen where there is a substantial amount of evidence demonstrating that the injury was caused by the employment relationship, and that's in some way, shape or form related to their general protections claim, has there been a trend towards ordering compensation in that regard?
No, there's not. And I think the premise of your question is really, it has to be stated really carefully, because this is a wide window. Almost every employee and most contractors in the nation are covered by general protections. So the street's wide open, as it were, to make a claim of that kind. But maintaining that the psychiatric or psychological injury was caused by or exacerbated by this factor and no other is often very difficult. So it's a different proposition, and I think your question was put this way, to say that it was caused by the employment. For that we have a bullying regime under the Fair Work Act, and we have common law bullying cases that are run, not always successfully, in the Supreme Court. But saying that someone's psychological injury is caused by or exacerbated by the dismissal, which after all is the contravention focused on by Section 545 sub 1, is a very different kettle of fish, and on that Ms Cassis and the Republic of Lebanon is way out on her own. My point, I guess, is that lots of other people are trying. Lots of other people, some I think with almost no prospects of success, but some certainly with some prospects of success.
I've got a quick question for you, Tim.
Oh, beauty.
Now, you commented that the principles in relation to economic loss are similar for general protections claims and
Yes.
unfair dismissal claims.
Yes.
And so that just turned my mind to the reinstatement issue.
Yes.
I mean, notably, unfair dismissal has that emphasis on reinstatement, and that's meant to be the primary remedy. But when you get past that, would you make a similar comment in relation to the principles that govern reinstatement under general protections and unfair dismissals?
There's no primacy for reinstatement under general protections. It's not the first port of call or the default to be excluded or anything like that. It's merely another one of the 545 remedies. So in that suite of remedies that you have, the first and most important discretionary factor is the applicant seeking reinstatement? Because if that's the case, it's game on. Then all the other questions I've indicated, all the other discretionary factors about how long that person would have served and to the extent to which returning them would be useless or useful, those fall into place. But the separate question on compensation is a really interesting one, because there's no guarantee to compensation. Someone could bring an application, and I used the example of Futuros before. If the relationship had broken down to such an extent that the respondent could have dismissed the applicant for a lawful reason, not for a prohibited reason, in any case a week after, there's no reason why that person should be given an enlarged amount of compensation. There's no reason at law, and there's no reason in fact. So really what we're talking about is bringing a cool eye to the facts of your case, because certainly some of the demands for compensation have been fairly generous to the applicant making them. All right, folks. If those are the questions, thank you very much for coming.